Or calls the case recalls the case, People versus Sean Courtright. You're leaving for the day? Come here for a second. Counsel, approach. You better bring a supervisor because you're in trouble. To work with you on everything that I've tried to work with you on.
I had just got out of jail. I didn't have money. I don't have money for that. If I go to jail, I'm gonna lose my housing. I've been kicked out of therapy. Everything that it was helping, I've been kicked out of. I'm not able to attend my women's trauma group because I had court Wednesday. I had just got that started back after a year. I see my baby. I haven't seen her in 6 years going through this court stuff, them sending stuff to the wrong address. My baby gonna be 18. I don't have a natural parent child bound
Every
with my
case
daughter.
before me, I've tried to work with you. I have.
I'm just not
appearing on certain things. I've done everything I possibly can to try to facilitate the process for you.
If somebody
But I can't.
for, I don't
if you
have.
want to keep interrupting me, you can keep interrupting me, but it's not going to get you. But the cold-hearted reality is that when you're given bond conditions, you have to comply. You can't just go over there and say, I'm not going to do it.
I didn't say that. I called my attorney and spoke with him and voiced my concerns with that. I'm physically not able to do that. I have issues, health issues with that.
Well, it's going to have to be
And
addressed.
I can't
Judge Valvo
physically-
regarding her release. Defendant's bond is revoked. She's remanded to the Washington County Jail.
Excuse me, I'm gonna lose my housing. Like, my rent and stuff is due. Well, can we talk again? Because I didn't talk about this with you, Mr. Lucas. I got rent coming up. I'm gonna lose my housing. I can't see the daughter. What is this about? Like, what did I do? Please say something before I come back.
All right then. 14A will stand in recess.
All right.
Court does call the case of the people of the state of Michigan versus Tomika Slip.
Hi, Mr. Simpson.
Good morning.
How are you?
I'm fantastic. And you?
I'm good. Did you have a good Christmas?
Yeah, a while back I certainly did.
Me too.
And you?
I got a Christmas present.
Yay.
Somebody
got one.
crochet me a teddy bear.
Oh, fantastic.
Yeah, I loved it. And cuddle with it every night. Its name is Brown Bear.
No relation.
Not going there.
And you still
relation.
got
All right.
that beautiful smile. You still got that beautiful smile.
Andrew Childers is written on behalf of
Warren Brown.
Nice of you to finally speak up. Go ahead.
Warren Brown, Deputy Chief Public Defender, appearing on behalf of Ms. Schlimm, who has already introduced herself.
Yes, she has.
So this is a you hearing. We don't have any updated.
our office received a report.
I have a date. I have a report received February 19th, dated February 11th. Is that the one you're referring to?
Yeah, I checked our materials. As of yesterday, we haven't received it. We just got it yesterday.
We received it yesterday, yeah.
It's competent. That's right. Okay. So the finding is that my client is competent to stand trial. In which case, Your Honor, since we've had a chance to review that, has the court received that same report?
I haven't reviewed the same.
We have no further evidence.
All right. Any other evidence from the people?
Nothing on behalf of people, Your Honor.
All right. The court would find, based upon that report, that the defendant is competent to stand trial. Specifically would indicate that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. And so the defendant is therefore deemed competent.
Thank you, Your Honor. We will tender a finding in order to the court this afternoon. At this time,
I'm going to need 5 orders.
5 orders for 5 cases. Yes, Your Honor. So At this point, we will to adjourn so that we can do a probable cause conference.
All right,
I think 2 weeks is the minimum you'll need.
Yes.
all right. So probable cause conference will be set for March 13th,
March 13th.
2025.
Did that mean I come back to court on the 14th?
Yes, ma'am.
And we'll talk to you in between that time.
We'll see you in a couple weeks.
Okay, I'll see you later, Mr. Cedric Johnson. And you
All
are.
right, bye.
My mama watches your podcast.
Okay. Yes, ma'am.
Bye-bye.
All my clients are that happy to see you.
I know. Yeah. It's nice to
I'm
have somebody happy.
sorry.
All right, take care.
Miss, can I go?
Yes, you can go.
You have a great day. Have a great couple weeks. See you in a couple weeks. Bye-bye.
You too. Court calls case People versus Marquise Hankey.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Attorney Kevin Basant, P 71061, on behalf of Mr. Marquis Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey. All right.
And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine, when appropriate.
During the matter, March 13th, 2025, 9 a.m. Yes, that's about.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say, but.
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located. And they stopped supervision. I also wanted to address his jail before he got out.
And you're aware of this?
I am, Judge.
And I also wanted to address his jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, I need you to do me a favor. So you have that number right, and the person says, whose number? He does, who is the victim. He says, I can't say the name, I can't tell you, but I need you to do me a solid. He said, okay, what? Tell them I'm thinking of you. And he says, the defense says, y'all been talking, right? He says, no, I've only been talking to Peter, who's the victim. He says, can't see that name on the phone, because she's my case. And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he would be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well as a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
Absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey, he's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittingly, he cut his tether off. I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it honestly, Judge. And if hear me out, Judge, I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor, I would.
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSE fourth and a dismissed DV from 2022, which the victim failed to appear as well.
Judge,
Go ahead.
Community Corrections have the tether back. And there's been communications with the Tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. It was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have the bond violation, at least with the Tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this Tether. Again, Judge, he could have been like everyone else and just not come back or got caught.
We would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case, and I'm just asking for a second chance.
Counsel, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And then on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Kia, who is the victim?" he goes, "Don't mention her. She's my case." So I have great concerns that he would still be violent.
He's just playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked, defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with the bond at that point, but right now he's remanded.
Thank you, Judge.
Thank you.